case, all right? Not at all. What this new law that was put into effect on September 1st of this year, 2017, what that basically did is it just tried to eliminate frivolous lawsuits and insurance claims when it came to like natural weather disasters. Really, Governor Abbott, his idea and his purpose behind it was hailstorm damage. I guess there was a lot of problems with people filing, bringing lawsuits in regards to hail damage that were not legitimate. But it applies to any kind of natural disaster, such as what we experienced here down the coast of Texas, Hurricane Harvey. So if you were affected by that, pay close attention here, especially if you did listen to a lot of this nonsense where you feel like you might not still have rights or remedies. You do. So number one, that new law, it added a chapter to the insurance code, chapter 542A. And all it does, number one, it requires that demand letter to have those three specific things I talked earlier about in this vlog. Stating the attorney's fees, stating the act or omission that occurred, stating the damages that you feel like you're entitled to, right? So it requires that, so you can't just state a general claim. Number two, what it did, there's a penalty for insurance companies that are in violation of any of these things I talked about previously, such as untimely paying or abiding by the terms of the policy, or not, or falling within that 5-day period to acknowledge receipt of the claim, to properly investigate the claim, and to pay the claim. All right. Prior to this new legislation, there was a set 18% per annum interest rate that was applied to any judgment against an insurance company for a violation of one of these previously mentioned items. So now, all it is now that 18%, that judgment rate is 5%, right? It's a fixed 5% rate plus whatever the judgment rate at the Federal Reserve is on that day, right? So currently I think it's around 5%. So you get 5% no matter what, plus that Federal Reserve judgment rate on that day. So today would be around 10%, right? 5 plus 5. But that could range from anywhere from 5 to 15% in addition to that 5%. So given the day and what the Federal Reserve decides to set, it could be as high as 20%, probably unlikely, but that range could be anywhere from 10 to 20%. So it's not gonna be a fixed 18, it's gonna be somewhere between 10 and 20, right? So what does that really mean for you? I mean, I guess it really means how much are your damages and how much is that really going to affect you deciding to file a claim. It really shouldn't. And the effect of it is not that significant if you ask me, right? It doesn't bar you from filing a claim, doesn't at all prevent you from seeking justice and getting what's rightfully yours, right? So understand that you still can file a claim. Understand the statute of limitations on these things are 2 years from the time the act occurred, right? Or the time that you gain knowledge of the act, or the violation, or the misrepresentation of the terms of the policy, right? So you have 2 years. And keep in mind, backtrack a little bit, that 60-day notice, that's the first thing required. If you're on that verge of statute of limitations at 2 years, and that 60 days, if having to wait that 60 days for that demand letter to go through would ultimately bar you from getting your lawsuit in, filing with the court, then that's waived. You don't need to do that, right? So if you're within that time period where the statute's gonna run, and if you don't file that lawsuit now, you're not going to ever be able to do it, then you don't need to send that demand letter. Okay, so bear with me again. Yeah, I mean, most of the other legislation, I'm just referring to some notes down here. It's really after that, I mean, as a consumer that's bringing a suit, that's probably what you really need to be concerned about. Most of the other mumbo jumbo in that legislation is about more stringent requirements for us attorneys and accounting for our fees, right? So hopefully this helped and gave you a better understanding of your remedies and your rights under the insurance code and what you can do to seek justice, get compensation you deserve, and you have a legitimate claim under the Deceptive Trade Practices Act. And keep in mind, I'll make future videos about the Deceptive Trade Practices Act, the Dtpa here in Texas. Like I said, this could apply to anything. It could apply to you go out and buying a truck, right? Or leasing a truck. You're seeking or you're acquiring a good, a truck. And whether that's for lease or purchase, you would qualify as a consumer. So if that sales guy, misrepresented something about that, you would qualify as a consumer that has a legitimate misrepresentation claim under the Dtpa. So keep in mind, this is a very, very broad act that Texas provides for. And we as consumers in a very consumer-oriented society, we're buying, leasing, or seeking to buy or lease these goods or services pretty much every day, right? So keep this in mind. Always get things in writing. If you can, ask questions, always. Please comment on this vlog. If you have questions, comments, I like interaction. I'm here to help. That's about it. If there's any other things that you feel are legal issues that might be prevalent and pressing our communities, leave that comment as well, and I will try to address those on a new vlog. All right, well, thank you all for watching, and I hope to hear from you.